Good morning. This is Katy Armstrong on Monday, the 10th of March. Today we have a number of important immigration changes, and at IntoNZ, as usual, we've got your back. I'm going to take you through some slides. I have marked what's relaxed, what's tougher, what's maybe new, and what's unchanged. How we got here is that last year in April, the minister had to slam the brakes on the AEWV, basically because it had been out of control. And a year on almost, it's time to lift that foot off the brake somewhat and get us back into balance. So it's good news for employers, it's good news for migrants, because a lot of what we're going to see represents relaxations to the current rules. So let's crack into it. The first question that we have been asked a lot by employers is, do I still need to do a job check? Now, the answer is that the job check is still a necessary part of an accredited employer work visa. There are two situations where you don't have to do a job check. One is if you're buying an existing accredited employer business and you want to switch the workers over to your new entity. They've said you don't have to have a job check. And the second situation is where your worker can reuse the existing job check that you did for them in order to be able to extend their visa. These changes, as we'll see, has broadened out the number of people that are going to be able to do that. So you still have to do them in most situations. Removal of the median wage, this is a huge deal. So as you know, with this AEWV in 2022, they decided to introduce a median wage as a sort of proxy for skills. So it was the wage that determined things like the length of your visa, not the skill level. The median wage has resulted in a skewing of the wages. We've got workplaces where there are migrant workers earning more than their Kiwi counterparts or other migrant workers on different visas. So the government's decided to just get rid of the median wage. It was in the coalition agreement. This is only currently for work visas, not for residents, and it affects AEWVs and seasonal specific purpose work visas. So we're going to go from median to just market rate. So what is market rate? Well, precisely what it says. It's the rate the market generally pays, and clearly there are going to be regional differences. The onus will always be on the employer to prove that they're within the market rate. At an industry webinar last Thursday, Immigration said they will be coming out with a visa pack with more information on how they're going to figure out the market rate. But for those of us in the industry for a long time, we know that they're going to rely on different sources. It could be the government careers website, or could be an industry or recruitment survey. I mean, basically a credible source that reflects a decent sample size. And if there's conflicting information, they may well not go for the lower rate. So be well armed when going into a job check is the advice. Question, what if I'm already paying above market rate to a worker on an AEWV? The answer there is, well, you need to honour the wage in your employment agreement or you'll be in breach. However, what if I have a job check approved at the median, but I've not yet offered out that job? Well, in that instance, you can now offer out the less than the median, provided you can prove that is the market rate. In some cases, of course, market rate will be above the median wage. So this anyway is leaving it much more open to you to prove your case. And if you do offer someone out after you've already had a job check approved, then clearly they're going to look at that wage as part of the AEWV, not the job check application. Now here's another important feature of the changes that's a relaxation, and that is the reduction of the minimum skills test from 3 years to 2. This is because in the country there were people that were able to get in originally with no minimum skills test in place, and they simply can't prove 3 years. So the government's decided, well, if, to help employers retain workers already in New Zealand who've got 2 years experience here now, this will facilitate it. Question, are there other ways to meet the minimum skills test without proving work experience? This is important because you may have a candidate who has worked but doesn't have any particular proof. Depending on the country where they got that evidence, there might not be pay or tax records. So yes, the alternative to meeting the minimum skills test is by having a relevant level 4 qualification, or a bachelor's degree in any subject. So it doesn't necessarily have to be relevant to the work. So question mark, does it mean all workers only need to prove 2 years of work experience? And the answer there is no, not necessarily. And that's because the minimum skills test is only one of the tests that a worker has to meet. The other test is what we call the suitably qualified test, and that's where they have to meet what you, the employer, have stipulated in your job check. So if, for example, you asked for a worker with 3 years experience, then that is actually what they have to prove. It overrides the minimum skills test. Now, this is going to be good in terms of saving money for migrants. They will now get 3 years on their visa for skill level 4 or 5, whereas they were just getting 2 years and were having to renew and pay a whole visa fee, which is $1,540, to get 1 more year. So that was pretty tough. Now, that's not going to be necessary. They'll get 3 years from the start. The maximum continuous stay remains 3 years in total. Does my worker still need to do an English test? This is completely unchanged. The answer is yes. So a lot of employers got a bit confused when they said we're reducing the minimum skills test. They thought maybe the English test was also gone, but no, it's still there. And the people that have to do it are those who are in a skill level 4 or 5 role that's not paid, even if it's paid, sorry, the 1.5 median or is on the green list. There's some more information on that slide about the tests that can be sat. The standard's not that high, it's just an IELTS 4 or equivalent. There are exemptions for those people who are either citizens of or have qualified at bachelor's or higher level in Canada, Ireland, UK or USA. Now here's an important change, part change, part unchanged, a little bit of relaxation you could say, but not entirely. So this is saying that employers will no longer need to provide evidence in a job check application of what they've done with MSD or work and income. Instead, you just need to declare that you have engaged. This is for the skill level 4-5 roles, by the way. So you only have to go to work and income for those level of roles. What does good faith engagement mean? Well, it includes that you've been contactable about the vacancy, you've listed the role unless you were advised by work and income that they didn't have anyone to send you. You've made sure that you haven't asked for anything different of work and income to what you may have advertised elsewhere. And here's an important one, that you've allowed enough time for candidates to be identified and referred, usually about 10 working days. Now, previously it was a mandatory 21-day listing, unless work and income didn't have anyone. So now they've taken that out and they're just saying it's whatever is enough time, so that could be 10 working days. Good faith is also interviewing candidates who you deem suitable. You have to keep evidence of what you've done for at least the duration of your current accreditation period. This is very important. So question, sorry, do I still have to list with work and income? The answer is yes, and the listing process is the same. The same links apparently apply. The difference is as I say, you're going to just be making a declaration. You're not going to be necessarily uploading your evidence. Immigration New Zealand has said they may accept your declaration at face value. However, if they hold any information that you might not be genuinely engaged with work and income, they can ask for more. They're going to probably check a proportion of the declarations directly with work and income to help detect non-compliance. Any false declarations can lead to suspension or revocation of accreditation. One thing to note, and this is not actually a change, but it was introduced last year, the contact person on a listing can't be, for example, us. We can list for you, but we can't engage with work and income. It has to be you, the employer, directly. Now, something that's got tougher from today is when a worker can support their dependent children onto dependent visas. It's a pretty big leap. Previously, they were able to be earning 43,322. Now that's leaping up to 55,844. If children were already, prior to today, either on dependent visas of your worker or had already applied under the existing threshold, will continue to apply. But there are fishhooks in this policy, and you really need to be aware. For supporting a partner, it's a little bit more relaxed. They have to be earning $26.85 an hour, but they can only be in a skill level 1 to 3 role unless they're paid at least $50.34 or meet the green list requirements. Partners who met partnership requirements last 26th June will also still be able to apply under old thresholds. Now, why should you, the employer, care about all of this? Well, you know, a lot of the time workers are weighing their options as to whether or not they can support their partner or children. One of the big fishhooks is that immigration is only going to take into account the guaranteed hours in the contract, not the hours that have been actually worked. So we do see this sometimes where the contract of employment only guarantees maybe, say, 30 or 32 hours, but the worker has consistently been working 40 plus. The problem there is that, this could impact their ability to support their children. So you may, as an employer, want to think very much about what guaranteed hours you put in the contract. We can help with the calculations, and we do recommend advice is sought. Now, this will be happy news to quite a few people, employers and employees, and this is all about recognizing more jobs at skill level 3. Now, how this works is we've got 3 columns in front of us. The column on the left, where it says cook down to slaughterer, these are going to be newly recognized at skill level 3 instead of skill level 4. So this is going to impact employers in that you won't have to go to work and income anymore for these roles. And for the worker, they're going to be able to get 5-year visas. So potentially they can also support their partners because they'll be in the right skill level. These roles are going to go onto a new Appendix 7 they'll be called Part 1 of Appendix 7. As a bit of backdrop, these roles are all coded to skill level 3 in the NOL. The NOL is the New Zealand occupational list that at some point is going to replace the ANSCO, and so that's why they've plucked these roles out and put them into Appendix 7. The roles in the middle have not been upped in the NOL, but clearly, I guess, the employers out there have probably lobbied government to say that these jobs are important, and so these are going to be in something called Part 2 of Appendix 7, And provided you, the employer, stipulate in your job check that you need at least 3 years experience or a level 4 qualification, they're going to be able to be recognised at skill level 3 instead of skill level 4. So again, somebody like a forklift driver can potentially support their partner, get a 5-year visa. It's significant. Please note that this is only for temporary visa purposes. This is not signalling that a forklift driver or a cook can claim points, for example, towards residence. So at the moment, this is purely about AEWVs. The roles on the right, these can also be recognised at skill level 3, provided you, the employer, stipulate, again, 3 years of experience or a level 4 qualification. These are unchanged, and these ones actually work for residents as well. I'll be talking more about the NOL at the very end, by the way, but this is all quite exciting news. Probably the biggest group will be the cooks. So what if a worker is in a role on that list but was previously coded to a skill level 4? What does that mean moving forward? Well, what it means is that they can now be considered skill level 3 no matter what. So yes, they could be on a visa that's behind the scenes saying they're a skill level 4, but they'll be able to support family members, assuming the income thresholds are also met, and they will now be able to extend their stay to 5 years. A word of caution about the cooks: we do still have a classification called fast food cook, and they remain a skill level 5. Now, what immigration has also said is, for example, if you had run a job check, say for a cook, but you'd only asked, not cook, for a machine operator, those ones that are in the middle, a machine operator or a forklift driver, and you'd only said, I want 1 or 2 years experience, those will be still treated as skill level 4, not skill level 3. You would have to redo a job check for that to be considered a skill level 3 job. So caution there. Now this is mega, as I've called it, because here they've signalled that, they've basically rewritten the rule as to when a job check can be reused to extend a visa. Think about it, there are thousands of workers out there who may be on either a 2 or a 3-year visa, but they're entitled to be in New Zealand for longer. And now the rules until today were supremely complex, and we kept having to go back to immigration to interpret them. What they're saying now is basically pretty much everyone who's already on a visa or who's already applied for a visa as of today is going to be able to reuse their job check to extend. That's provided they obviously are extending using in the same job, in the same occupation, and no lower than the pay rate that was on their visa. There are 11 roles that have been chosen not to be included in this, but again, only if they weren't paid $29.66 previously. So here's the list. If you were, for example, a ski technician on $28, you're not going to be able to extend your visa using your old job check. So let's say my worker had a skill level 4 or 5 job check, got a 2-year visa. Can we reuse the same job check to support them to extend for another year? And the answer now is yes, provided you, the employer, is still accredited, same job, same location, same pay at least. They will have to meet English language requirements, and they do have to meet the minimum skills and suitably qualified tests. So this is a very substantial win for many, many employers and workers. For you, the employer, it means you don't have to go through the costs of a new job check. And for the employee, they don't have to worry about a Kiwi suddenly surfacing in a new job check or a new set of advertising for the job that they are already in. So lots of good news there. come back to this English question because we keep getting asked this: does my worker need to meet English testing and the minimum skills test if they're reusing the same job check? And the answer is yes. So this is if they're in a skill level 4 or 5 job. Mega relaxation here. If an application lodged prior to today is still on hand on or after today, then immigration is going to apply the most favourable rules, which is a complete turnaround, because normally the rules that they apply are the rules that were in force on the day that you lodged something, not the day it's decided. But this is a very pragmatic approach. Now, coming up in April, so next month, we're going to have some further changes, and these will be to interim work visa rights. This is another relaxation, because normally, so what are interim work rights? Interims are when someone is applying for an accredited employer work visa, but the current visa that they're on is expiring, and in that bridging period, they go on to an interim. Well, normally, unless you're going from accredited employer work visa to accredited employer work visa in the same job, you wouldn't be able to work in that interim period. So, an example would be a student applying for an accredited employer work visa. They'd have to wait for the final decision. But now what they're saying is you're going to be able to work in the job even though your visa hasn't been decided. If you do that, then the time spent working will be counting towards your MCS, or maximum continuous stay. You will be able to claim points for time on an interim visa if all else qualifies. So this is really significant, and I guess it's to again reassure employers that they don't have to be waiting long periods to get their worker. The only word of warning, of course, is if you, the employer, do start them in the role and their visa was to be declined, then you would be in a position having to terminate. So that might be something you want to get advice on. Obviously, if we're working with you and with the candidate and doing their visa, we will have become aware if there are any particular risk factors. And provided the employee agrees, we can share that information with you. Now I'm going to finish up on some statistics, because it's always good to get a bit of an overview of where things are at, and then I'll bring you a bit of tea leaf stuff. So at the moment there are 25,887 accredited employers. That is well down from the almost 35,000 or so that we had at the peak. So we are aware of employers who have been struck off, or employers that have not, for one reason or another, renewed. The total number of AEWVs approved since the beginning of the scheme is standing at 141,000, just over. Now, the next bullet signals what are the results, basically, of last year's foot on the brake. Last month, February, only 689 AEWVs were lodged offshore, compared with 9,366 2 years back. It wasn't even the lowest month. The lowest month was last October, with only 452 lodged. There are more applications being lodged onshore. That's because milling around in New Zealand, there are students, postgraduates, and other people maybe changing jobs or extending their visas. And so that cohort are now dominating as compared with the offshore applicants. We do expect to see that turn around, because employers are already seeing that there's sort of the pool of migrants onshore is now pretty much exhausted. So, it will become necessary in more cases to start hiring again from overseas. And now that the system's working much better, everything's much more in flow, things are quick, it is going to really help employers, I think, in 2025 moving forward. I've given all the resident stats. I'm not going to read those out. You can mull those, but just to say that the numbers are supremely low as compared with pre-COVID times, with only 6,184 residence applications approved this year to date. We're not in a full year. The full year will finish at the end of June, but notwithstanding these numbers are pretty low, they are going to go up because more people are sort of working towards qualifying. But yeah, it's the squeeze has been on, and that therefore brings me to my next slide, and I've only got one more left. This is about the tradesies. So there is hope. This article from the Gisborne Herald is last October, and it's where the minister was recognising that we've got a lot of skilled tradesies in New Zealand already who no longer have a pathway to residence. They're all out there anxiously waiting on news. She said that she recognised, having to have a degree or be earning 1.5 the median wage was simply out of reach for many. So we are hopeful of some changes in that regard. And I'll leave you with the final word. It's about the NOL, this New Zealand occupational list. I have been deeply involved in trawling the NOL and communicating with the statisticians who are now managing the NOL here in New Zealand. There are some really interesting things coming into the NOL. Well, they're already there actually, but immigration hasn't for some reason yet decided to put them on any lists. But one role to watch out for is hospitality duty managers that have been put to skill level 2. This has been a bugbear for a long, long time because duty managers carry a lot of responsibility. They can be fined up to $20,000 if they serve alcohol to the wrong person. And yet they've been, like a hot potato, often relegated to a skill level 4 waiter. But now they're going to get their own category. And there's even another category there, food and beverage supervisor at skill level 3. So there's going to suddenly potentially be quite a lot more options in hospitality. And I've noticed over 20 new supervisory roles also in farming and manufacturing, etc., all again at skill level 3. So that's pretty potentially exciting, depending on what Immigration New Zealand then does with the NOL. So sort of a little bit on tenterhooks. What I've got in front of you is an extract from the immigration website where they've said it will take some time for them to transition to the new classification. So they're going to continue using the ANSCO until such time, and they will provide a further update in 2025 when they've confirmed a switchover date. But again, very much a watch this space. Here at Into-NZ, we will be with fingers firmly on the pulse and letting you know what news comes. So that's me for the 10th of March. The instructions will be going live right now. The online systems will have been adjusted. We'll be taking a look at those. Please feel free to click on the buttons below to download these slides, also to ask a question. You can do that by the form that we've given, or you can ring us on our office number 07839 0967, or you can email any one of us at any time. Ka kite.